Hello. Today we are whipping through a video on 3.1.14. So the last key knowledge point from Area of Study 1 of Unit 3. So the last key knowledge point from the criminal justice system, which is focusing on reforms. Quote today is, again, from our favourite quota, unknown: be somebody who makes everybody feel like a somebody. Yeah, look, I believe I've said it in other videos. I think at the end of the day, one of the main reasons we're hopefully here on this earth, and one of the purposes of it all, is to just try and make other people's lives better. I think we all have that capacity, and I think you'd all agree that, you usually feel pretty good when you make someone else feel pretty good. So it's just that idea to try and remember every day to try and make other people feel like somebody and try and make other people feel important. And even if that's just to get a bit of a kick out of it yourself. I think just trying to focus on doing nice things for other people is a good way to live your life. As I said, we are working on reforms today. So the last dot point of Area of Study 1, Criminal Justice System. And this dot point is recent reforms and recommended reforms. So this is actually the third time I've filmed this video, as opposed to a lot of the other ones that haven't changed in the last 4 years, because this point with the word recent there and what's recommended does change sort of every year in different ways. More or less, the essential question we're going to be able to answer is, what are some recent reforms and some recommended reforms that would improve the justice system? And that's really focusing on that skill, is around how they improve the justice system. So, recent reforms. The study design's really clear on this. They have to be in the last 4 years inclusive. So basically for this year, they have to have been from 2017 onwards. So just double check if you're using textbooks that were printed for this study design. You should still be mostly all right. But if they've got things in there, say 2016, they're out. So just be careful with that. So 3 reforms. This one is, we're going to go through 3 reforms. This is the last year that this one can be used. So I'll have to update this video again next year. But this is the reform to decrease the number of jury challenges that each accused person has. So more or less, if you're accused of a criminal offence and you decide to plead not guilty and go to trial, when your jury is being impanelled, you used to be able to, or you still can, basically, as people are randomly called out, and usually, or these days, their number and their occupation is called out, just based on the look of them and their occupation, you can challenge a number of those jurors and they no longer end up on your jury. And you used to be able to do this 6 times. So you basically pick 6 out at random, as they're called, if you don't like the look of them, and they wouldn't end up on your jury. The problem is, when the VLRC reviewed this in 2014, the law wasn't passed in 2017 though, they basically found that female jurors were much more likely to get challenged than male jurors. And they found that this was particularly true in general cases involving violence, but then particularly sexual assault cases where so often just statistically, the perpetrator or the accused person is male and the victim is female. And they found basically in these cases that accused people would just save up their challenges and just use them on females. So as you see down here, more or less 2 women were getting challenged for every bloke that was challenged. And what we started getting was skewed juries, where I think the average was sort of spitting out that, on average, a jury would have 6.5 men and 5.5 women, more or less meaning that, often juries were 7-5 male weighted or 8-4 male weighted. And Obviously, what an accused's lawyer is going for is that they want, male jurors who perhaps are able to better empathise or sympathise with the male who's charged with the crime, and as a result are more likely to find not guilty. What this means, though, is you end up with juries that aren't representative. You end up with juries that aren't therefore fair. So the idea was that, hey, if we reduce the peremptory challenges available from 6 to 3, you limit the amount of influence an accused person can have on their jury composition. So fairness there, a little bit of access, particularly for females. So some good principle of justice links, and equality. It stays the same for everyone. This one is a reform from last year, so very, very fresh. And this is the fact that due to COVID last year, we actually called off jury trials in Victoria for over 6 months. We basically, with all the social distancing guidelines and the lockdowns and the like, the court system had no choice but to say, you know what, getting lots of people from different walks of life to congregate in the one spot, people who don't know each other, and then go home at the end of the day is probably a really good way to maybe spread a pandemic around. So they basically said we can't do any jury trials, which has subsequently, and we'll talk about this as we get through these recommended reforms, created a really, really big backlog in our criminal justice system. So something like, I think, 1,500 cases should have been heard in the time that basically trials were called off. So that just adds significant delays. So one of the reforms they brought in during COVID to try and address this was that in some circumstances, they were going to allow judge-only trials. So basically, if you, as an accused person, didn't want to wait for jury trials to recommence, you could basically apply and work with the prosecution and agree to have your trial heard by a judge alone. Now, the whole idea here is that then the judge basically does everything that the jury does, as well as doing the rules of evidence and procedure and basically dealing with points of law as they arise. The judge then also becomes the arbiter of fact. The judge listens to the evidence and more or less at the end of it decides on a verdict of not guilty or guilty. Differently, though, than a jury doesn't have to, as we know, provide the reasons for their decision. They provide a verdict and that's it. Their reasons stay secret. Their deliberations stay secret. The judge actually had to explain why they made the decision. So actually give their reasoning, which a lot of people in the legal profession see as a good thing. The idea that it has to be explained why someone is convicted. But obviously that could potentially open up avenues for appeal and the like. But more or less, the whole idea was that we reduce delays. And if we reduce delays, we therefore pretty much hit really heavily on access. So this is a really good one that you can jump in straight away. Hey, a recent reform was that during COVID, we couldn't have jury trials. So the Parliament passed a reform that allowed for judge-only trials. This was to try and reduce delays. So yeah, really, really good one that you can use. Our third reform is the bail and remand court. Now, this is a reform from 2018. And it was called for by a guy called Paul Coughlin, who used to be, he might have been our Chief Justice actually, or he was a Supreme Court Justice nonetheless. And in the wake of some serious incidents in Victoria where people on bail committed offences, they basically did this big review into our bail system. And one of the recommendations from Justice Coughlin was to establish a dedicated bail and remand court. So it operates as part of the magistrate's court, rather than just schedule bail and remand hearings into normal courtrooms wherever they fit, and therefore you can only do them during sitting days, during the day, and therefore, people sometimes don't get in, it causes disruptions. Basically set up a section of the court that just hears bail and remand matters. Have a magistrate rotating through there, and basically that's their job to just sit there and do that. So they work different hours. I think their hours daily are like 10 a.m. to 9:30 p.m., so much later than regular court operates, and open on weekends as well, with basically, as I said, dedicated magistrates who work through the bail and remand court more or less on circuit. The whole idea here again is there's a lot of access involved. It's about reducing waiting times, particularly on weekends and stuff like that. If someone's picked up, they don't have to wait until Monday to be potentially released. But also, as we can see from this graphic, this is the first year of operation. They heard, or 11,000 accused persons appeared before the bail and remand court, and almost half of those appeared during night sittings. So basically, we've increased access for more or less 50% of people who need bail, who need to face the magistrate's court for bail. So those 5,085 people in the previous system would have had to perhaps stay overnight in prison until there was room for their hearing to be heard in the regular court. It's also good to look at this one. Actually, 18% of those were finalised at that hearing, more or less. They were able to agree to some form of diversionary program. Some of the people involved were, who were picked up sometimes, are people who are homeless or have drug issues, and the magistrate is able to actually immediately divert them into support programs and hook them up with support services, rather than basically institutionalise them in prison. So the bail and remand court has done some good work around fairness there as well, but particularly, again, heavily focused on improving access. This is the skill for 3.1.9, and it's a discuss skill, and we know a discuss is an exchange of opinions. Now, we've only had one question in now the 3 legal studies exams since the change. We've only had the one question asking for a reform or a recommended reform, and it didn't ask for a discussion. And I'll show you the question after, but it was a tack-on. So it was a 10-mark discussion question about, ways of reforming and different ways that you can try and influence Parliament. And in it just said include a recent reform. So more or less was just a bit of an explanation, but the explanation needed to be focused on the principles of justice. So more or less just what I want us thinking about with this skill is the idea of, okay, I know a little bit about what the reform is, decreasing jury challenges that went from 6 to 3 to just trying to make sure that we got a more representative jury. What does that mean for the principles of justice? So that's where we really need to think about these in terms of the discussion side of things. What does it mean for the principles of justice? Well, with the reduction in jury challenges, you improve fairness. Juries are more representative. If juries are more representative of society, you're going to get a fair outcome because you're going to remove any bias or prejudice if you're spreading that load across the community. Plus, things remain equal. It's the same number of challenges for all accused persons. It wasn't like saying, you're only going to get 3 challenges in some instances and still have 6 in others. It's down to 3 for both. We do need to, as a discussion, maybe think of the ways this could hinder a little bit as well. And that's just the idea that if an accused person gets unlucky with how the jury ballot works, they've all of a sudden got less flexibility, less opportunity to rectify this with only 3 challenges. Jumping down to judge-only trials, hugely focused on access here. They literally introduced this to try and get some cases heard while they couldn't use juries. So they're just trying to make sure that we didn't get to a situation where we're now, where we've got this amazing backlog of cases. Unfortunately, it didn't really work, but that was what they were going for. So they were trying to improve access, but they didn't really, because not many people wanted this option, which we'll explain shortly. You could also argue that the judge making the decision is fairer than a jury making the decision. So there's a little bit of fairness there, but decisions no longer spread across the panel. All of a sudden, trials are being decided differently, so there's a little bit of a lack of fairness, lack of equality there, perhaps. And again, dedicated bail and remand court, again, it is all about access. It frees up time. People get their stuff heard quicker. And that also has an element of fairness to it. But does it actually save time when it's just a reallocation of existing court resources? Maybe it doesn't. They didn't appoint any new magistrates or build any new courts for it. It's just reallocating what was already there. We'll now jump to recommended reforms. And recommended reforms are, they're not tricky, but they can be, just in the sense of they can't be made up. So about 5 or 6 years ago, there was a question on the old study design about reforms and recommended reforms. And one of the big things in the examination report about this for the recommended reforms part was basically that students can't make them up. They more or less have to have been called for someone. They have to be something that's reasonably rationally being asked for. So I've got 4 here. 4's quite a lot, but they're pretty small, easy ones to remember. And I'd recommend maybe just trying to keep 2 in your head. Know 2 quite well, but don't necessarily try and remember all 4. So first one is judge-only trials. And people have been calling for this for a while, but this is the idea that, hey, we brought them in during COVID. Why don't we just offer them all the time? Basically allow it so an accused person can apply to not have a jury. Maybe they don't want a jury. And it all stems from that argument that juries maybe shouldn't be making those big decisions about people's lives. They don't know the law necessarily. They don't know anything about the accused person. Maybe we should just leave it up to the legal experts like the judge. Particularly in our current social media climate, it's becoming harder and harder to actually have a case heard with maybe out some bias and prejudice, without someone being exposed to some news or information about the matter. And there's an argument that it's becoming therefore harder to get an impartial jury. So judge-only trials, particularly in really high-profile matters with known accused persons or known victims, judge-only trials might be the way to go to improve fairness. So that's definitely something that some experts are calling for. Committal proceedings. We know that they're complex. We know that they're lengthy from our understanding of them, but we also know that they're really important for a fair trial in terms of the evidence that they help or they allow the accused person to see, and gives them a chance to test that. So they're a tricky one because whilst they limit access, they might promote fairness. So rather than just being blasé about what they do, the Victorian government has actually sent this one off to the Victorian Law Reform Commission and have asked the Law Reform Commission to more or less consider alternatives to committal proceedings. And the Law Reform Commission's actually returned their report with a bunch of recommendations. And more or less the recommendations are about not so much scrapping the committal system, but really adjusting it and trying to streamline it and rename it so that things can hopefully move through the courts in a quicker fashion. So basically, they're trying to figure out a way to do these better than they're currently done. And a lot of that comes down to the fact that there's about 3,000 of them a year, and usually they take an average of 3 days per hearing. So that's 9,000 sitting days a lot. That's a lot of court time used on committals. So basically, recommendation-wise, some people are saying we should just abolish them. So more or less considering committal proceedings from that viewpoint of should we get rid of them. Increased legal aid funding. This is a super straightforward one. Just being really clear, if you use this one, this is something the Senate called for in 2018. You will learn later on that the Senate, even though it's part of Parliament, isn't necessarily controlled by the government. The government have most of the seats in the House of Reps. So the Senate voted a couple of years ago and said, hey, we pass a motion that we want the government to increase legal aid funding. So basically, about 20 years ago, a bit over, the Australian government was contributing 55% of legal aid funding, with states contributing the other 45%, obviously from their different tax systems, etc. A few years ago, that was down to 32% and 68%. So more or less, the Australian government has reduced the amount that they're spending on legal aid, and there's more or less this idea that we're not representing as many people as we could. And we looked at legal aid and we looked at the threshold for getting legal support and know it's extremely high. And as a result, more funding can only be good for improving fairness, access and equality. So a really easy one to use. Making sure you know that the Senate called for it, and they're calling for a return to 50-50 funding between the states and the federal government. Finally, this is a new one from just the other day, and really good that we can just add this really new stuff into our understanding. So our Director of Public Prosecutions, Kerri Judd, actually did an interview with The Age, and I can link you that in the notes below. And in it, she was asked more or less her views on what reforms the justice system needed, particularly in response to the COVID side of things. And she had some thoughts on committal proceedings and the like. But two that really stood out as good recommended reforms, because they're coming from the Director of Public Prosecutions that you could use, are increased sentencing discounts and increased detail in sentence indications. So not as like a long-term thing, but Kerri Judd's basically said, hey, since COVID hit, we basically couldn't hear 1,500 criminal trials. What's happened, therefore, is those 1,500 criminal trials are more or less added to the all the new cases that have piled up in the last 6 months as well. And all of a sudden, we have a really serious backlog of criminal matters to hear. And the big issue with this is that already, and as per the 2019 County Court report, more or less the average wait time for a trial was about 14 months. It sort of got a bit longer if your trial was going to be a longer one, but about 50% of trials in the County Court take between 5 and 10 days. So in sort of that 2-week time frame, and the wait for a 2-week trial was 14 months. So if all of a sudden you add in another 6 months where we couldn't hear cases, that means people are starting to get out to 20 months, maybe a bit more, and almost gearing up towards the 2-year mark. So basically, people are going to be sitting around forever waiting for their criminal case to be heard. So what Kerri Judd has said is, well, why don't just for a short period of time, for a short time frame, we tell all current accused people that we will guarantee you a 20 to 30% sentencing discount if you plead guilty. So we know that the Sentencing Council data says that the discount for a guilty plea ends up being around 20%. But in some cases, if you plead guilty really late, you might not get much of a sentencing discount, or if you plead guilty and it doesn't seem like you've shown remorse. She's basically saying, let's fix it in for a period of time. Just say no matter what, if you plead guilty in this time frame, somewhere around 20 to 30% reduction in sentence guaranteed. Basically what she's trying to do is incentivize guilty pleas, and by incentivizing guilty pleas, you remove a backlog of cases. You hopefully get more people pleading guilty, which reduces delays, and we know that reduction in delays means improved access. She's also said that, hey, it would be a good idea to allow judges to give more detail than just whether someone will be imprisoned or not. Perhaps they could give a range as well. Perhaps they could say, we would imprison you, but it would only be 6 to 12 months. So again, not just that, no, you're in jail or you're not if you plead guilty right now, but actually if you are in jail, how long are we looking at? What's the sort of time frame? And again, that extra information might further incentivize the guilty plea. And if we incentivize the guilty plea, we potentially remove a backlog of cases. We remove a backlog of cases, we reduce delays, we improve access. Again, linking to that principle of justice. So, same as before, we want to focus on that analytical skill of thinking about this reform or recommended reform in the context of fairness, equality, and access. And that's where our discussion is. So with committals, we're about saving court time and money and improving access if we can streamline the committal process. And also it makes it fairer for victims. They don't have to give their evidence twice, particularly sexual assault, etc., where there's a lot of push for reform around the questions that can be asked. And Kerri Judd says in the article that one of the big things that happens at committal proceedings is often defence teams go really, really hard at victims, harder than they would at trial, because they feel like a jury might be too sympathetic to the victim if they go hard at trial. So they go hard in the committal instead to really try and throw them off, which is a horrible tactic, obviously. So the idea that if we didn't have committals, we would increase fairness is a really valid argument. But they also allow fairness, so we need them for that side of things. But you might actually add to waiting times because committals and laying out all of the evidence can also incentivise a guilty plea. So if you get rid of that, if that actually leads to more cases being heard in court? So maybe not a good thing. As I said, increasing funding for legal aid is fairness, equality, and access. More people with lawyers means they better understand what's going on. Access, you're more likely to have the two best cases presented, fairness, and it puts you on equal footing with the prosecution. So really, really good links to the principles of justice with that one. Judge-only trial we talked about before. There's an argument that they increase fairness because the judge is a legal expert, but it also allows the accused person choice, which is fair, but it means every trial is not done the same way, which isn't equal. So there's a lack of equality. And finally, those last ones, extending sentence indications and having fixed sentence reductions for guilty pleas, all about access. You reduce backlog of cases by incentivising more guilty pleas, better for the system overall. Same issues with the appropriateness of plea negotiations and sentence indications, though, is that what if you incentivise a guilty plea so much that you actually incentivise an innocent person to plead guilty because it's not worth the risk? And then you've got an innocent person, even if maybe they're not going to prison, taking a criminal record because it was too dangerous not to. And that's unfair. So where has this question come up? As I said, it's only been on once since the new study design, and it was this question back in 2018. So as I said, it was a bit of a tack on. The prompt was the best way for individuals to influence lawmakers to reform the Victorian civil justice system is to appeal cases. Discuss the extent to which you agree with this statement. In your answer, explain how one recommended reform to the civil justice system may assist in achieving justice. Notice how it doesn't ask us to explain one recommended reform. It doesn't want us to actually give detail about the reform itself. It wants us to more or less identify, maybe outline briefly the recommended reform and then link it to justice. And this is what the report said. An explanation of how one recommended reform could assist in achieving justice. And really clearly, the question did not require an explanation of the recommended reform, but how the recommended reform led to justice. So it basically wanted you to reference one or more of the principles of justice. So where I go back to is this table here. And this one here. Yes, we need to know some details about these reforms and recommended reforms. We need to know what they are a little bit, because if we don't, we can't link them to the principles of justice. But the key thing is that we are thinking about them through the lens of how do they improve fairness, how do they improve equality, and how do they improve access. That's what we have to be really clear on, because that's what the exam is going to want us to do. Also, Just noting, you must be able to distinguish between reforms and recommended reforms because the study design says you must be able to. That means if the question says a recommended reform and you say something that's been introduced, you cannot gain marks. So just being really clear on recommended reform and reform, they both start with R, can get confusing. You must be able to put them in their correct box. So remembering that point as well, or you will not get marks. Obviously, we've already linked everything to the principles of justice, so we won't go over a table here, and you can add them into the table yourself. Look, some articles here. These are the two articles I've had in there forever, and I can link those to you if you want, including the VLC project on committals now has the actual final report. And this is the article that I spoke about a little bit in there, where Kerri Judd talks about the backlog of cases and ways that they might reduce that. I would absolutely recommend you have a read of that, and again, it'll be linked down below. Look, hopefully after that you can really give those brief details or outline some recent reforms or recommended reforms. But importantly, hopefully you can link them to fairness, equality, and access, because that is absolutely what we're going to need to do on the exam. Reach out if you have any questions as always. Otherwise, happy studying and good luck for a SAC that I'm sure you've all got upcoming.